we're going to cover this case. This is a case that dealt with corporations, but same rules would apply likely with LLCs, okay? We're talking about signing in the correct capacity. Now let's say, what is the capacity? Sometimes it's a little confusing. Well, if I'm going to sign a contract, I want to sign it not as John Smith, okay? I want to sign it as John Smith, President, okay? That means I'm signing in my capacity as John Smith, President of the LLC. And I've told people this for years, and they think, well, you're just, a little bit overly anal or something like that, right? Not that important. Well, it actually is. This is a case here, Wurzburg Brothers Incorporated versus James Coleman, where you'll see that one failure to include the designation resulted in liability for Mr. Coleman. Okay? Coleman was the president of Coleman American Moving Services. Wurzburg Brothers allowed Coleman to sign a note to pay the balance owed to Wurzburg. Okay, so Mr. Coleman had a moving services company. He rented some space from Wurzburg. Okay? He was late in paying, and Wurzburg allowed a note to be issued in which Mr. Coleman would pay off the amount owed on a monthly basis. Okay? Now, interesting, the note included Coleman American Moving Services as the party to the note. But Mr. Coleman signed personally as James Coleman. And what happened to Mr. Coleman? Well, Mr. Coleman became personally liable to the note. And what's fascinating about this case, at least to me, is that Coleman American Moving was one of the parties. Okay? This company was one of the parties. Okay? So in the original document, we probably would have seen something like, this is a contract between Coleman American Moving Company Incorporated and Wurzburg Brothers. Okay? So it was clear that Coleman American Moving Company was one of the parties, but Mr. Coleman goofed it when he signed as James Coleman. And I'm sure everyone knows how he should have signed would be James Coleman, President.